In the complex intersection of law, politics, and media influence, a new front has opened that extends far beyond a courtroom in Florida and reaches deep into the fragile architecture of American democracy, its legal traditions, and the global narrative surrounding truth, power, and accountability. The former President of the United States, Donald John Trump, has filed a multi-billion-dollar defamation lawsuit against one of the most prominent journalistic institutions in the world, the Wall Street Journal. The lawsuit alleges that a recent article published by the paper falsely attributed to Trump a lewd and inappropriate birthday letter supposedly sent to Jeffrey Epstein, a figure now globally known not for wealth or influence, but for the enduring shadow of abuse and criminal networks. The report claims that Trump drew a naked woman and included a handwritten note that read, quote, "Happy birthday, and may every day be another wonderful secret." The former president has categorically denied authoring the letter, denied drawing any such image, and denied writing those words. From the legal filing, Trump asserts that no such letter ever existed, that the very premise of the article was a fabrication, and that the journalists, editors, and even Rupert Murdoch, the executive at the summit of the News Corp empire, were complicit in what he describes as a calculated attempt to defame and degrade his character. The lawsuit is ambitious in scope. It does not merely accuse individual writers of poor reporting or editorial negligence. It suggests institutional conspiracy, malicious intent, and reckless disregard for truth, a claim that invokes the most burdensome legal threshold in defamation law, actual malice. Yet, as the details of the complaint began to circulate, legal analysts, media attorneys, and First Amendment scholars raised immediate skepticism. Among them is constitutional attorney Jeff Lewis, who was interviewed by Forbes shortly after the suit became public. His view is uncompromising. Trump faces, in his words, a, quote, "big hill to climb." The reason is embedded in both legal precedent and the jurisdiction chosen for the case, the state of Florida. There, to sustain a claim of defamation against a media outlet, the plaintiff must prove, not assume, not imply, but prove that the defendant knowingly published false information or acted with reckless disregard for its veracity. This standard is known as actual malice. It is a doctrine that emerged from the landmark Supreme Court decision New York Times v. Sullivan, issued in the year 1964. That ruling transformed defamation law in the United States by embedding press freedom into the legal framework of accountability. It held that public officials, and by extension, public figures, must tolerate a higher threshold of criticism in a democratic society, even criticism that is harsh or unflattering. In effect, the standard was designed to protect vigorous public debate, but it also makes defamation cases brought by political leaders extraordinarily difficult to win, especially when the claims involve journalism tied to matters of public concern. Trump's legal team will not only have to demonstrate that the story was factually incorrect, they must go further. They must show that the Wall Street Journal and its reporters knew the information was false and proceeded to publish it regardless, or that they failed to verify it when verification was not only possible, but required by the basic tenets of responsible reporting. This is not a technicality. It is the fulcrum upon which the entire case rests. Beyond this formidable burden of proof, Florida imposes a statutory mechanism known as the Anti-Strategic Lawsuit Against Public Participation Law, or anti-SLAPP statute. This provision allows defendants to swiftly challenge lawsuits that appear intended to chill free speech, especially speech related to public issues. In practice, it forces the plaintiff, in this case, Donald Trump, to present preliminary evidence at the earliest stages of litigation or risk immediate dismissal. Even before this threshold is tested, there is a procedural rule that may prove decisive. Under Florida law, a plaintiff suing a media organization must notify the defendant at least 5 days before filing the lawsuit. This rule is intended to allow the publisher an opportunity to correct or clarify the contested content. As of the most recent reporting, It is unclear and unverified whether Trump or his attorneys complied with this rule. If they did not, the entire case may be thrown out on procedural grounds alone, not for lack of merit, but for failure to follow basic pre-litigation protocol. Despite the lawsuit's aggressive tone and the astronomical damages sought, reportedly $10 billion for each of 2 defamation counts, totaling $20 billion, legal experts argue that the claims' foundations are inherently unstable. The court will look not at rhetoric, not at political implications, but at evidence. And as of now, Trump's complaint is described by some as vague, lacking in the kind of specific factual allegations that would demonstrate malicious intent. For instance, there is no detailed challenge to the credibility of the source who provided the letter, no assertion that the reporters had reason to doubt the document's authenticity, no forensic refutation of the handwriting or drawing, no reference to prior interactions between the plaintiff and the publication that might reveal a pattern of antagonism. In the language of legal analysis, there is no evidentiary backbone. There is only the denial and the demand. But if the case is unlikely to succeed on legal grounds, the question becomes, why file it at all? Why risk a counterattack from an institution as powerful as the Wall Street Journal, armed with elite legal counsel and decades of litigation experience? The answer may not be found in court documents, but in the broader terrain of political strategy. This lawsuit, regardless of its legal prospects, generates headlines. It reasserts Trump's stance as a victim of media bias. It reinforces a narrative that institutions, from prosecutors to journalists to corporate executives, are aligned in their mission to destroy him. This is not merely about clearing a name. It is about projecting defiance, about signaling to a political base that the fight continues on every front. In this context, the courtroom becomes a theater, the filing becomes a speech, and the legal battle becomes a proxy war, not over truth or fabrication, but over control of the national conversation. Yet the legal system does not operate on political optics. It requires something else, something colder. It requires evidence, admissibility, and burden of proof. And in Florida, it requires that these hurdles be cleared quickly, or the case will not survive to discovery. Still, if the lawsuit does survive that initial gauntlet, it opens the door to something far more volatile, a process that few public figures willingly enter, a phase of litigation known as discovery, where allegations are tested against records, correspondence, sworn depositions, and in some cases, cross-examinations under oath. And in this case, that path could lead into terrain that Trump himself has spent years trying to distance from. Jeffrey Epstein. The name Jeffrey Epstein is no longer tethered to social circles or elite philanthropy. It is now synonymous with systemic criminality, with clandestine networks of abuse, and with the enduring suspicion that many powerful individuals remain entangled in truths yet unrevealed. To file a defamation lawsuit that touches Epstein's legacy even peripherally is to invoke one of the most radioactive elements in the modern American political ecosystem. And if the case proceeds beyond the initial dismissal phase, the full machinery of legal discovery may be unleashed. This is no small matter. Discovery is not a rhetorical stage. It is evidentiary. It compels answers under oath. It demands documents, timelines, and testimony. And it offers no protection for narratives that conflict with material fact. In that environment, denials are no longer sufficient. According to legal analysts, the defendants, that is, the Wall Street Journal, its reporters, and its corporate parent, would have the right to compel a vast range of materials. This could include handwritten documents, digital correspondence, voice communications, calendar logs, visitor records, and potentially forensic analysis of the purported letter in question. If Trump maintains that he did not write, draw, or send the alleged document, the burden shifts to proving its fabrication. That opens a complex evidentiary chain. If the journal possesses the letter, even if it did not publish the full image, it may be required to produce it. This would then raise questions of provenance. Who provided the letter? When was it received? What were the terms under which it was examined or verified? If the letter exists and is proven to be authentic, the plaintiff's position collapses. If the letter does not exist, or its existence is unprovable, the case might still survive, but would require additional evidence of malicious fabrication. The legal terrain only grows more dangerous when one considers the implications of broader discovery. Trump's associations with Epstein, both verified and speculative, have been a matter of public interest for years. There are archived photos, public statements, past interviews, and contradictions. While no direct criminal association has ever been established, the optics remain volatile, particularly in light of Trump's efforts to distance himself from the late financier after his arrest and subsequent death in custody. If this case proceeds, the defense will almost certainly seek to establish context. That could mean requests for all written communication between Trump and Epstein, all materials referencing Epstein or his known associates, all documents relating to Epstein's known residences or travel, and any internal communications that might reference the preparation of public statements designed to minimize these ties. Legal experts have noted that even efforts made by Trump's team to research or suppress connections to Epstein could become subject to discovery. That includes attempts to review sealed criminal records, analyze civil litigation tied to Epstein's estate, or scrub references from affiliated databases. The act of seeking such information, if it occurred, could be framed not as obstruction, but as relevance. And this leads to the potential involvement of other figures. One name stands out: Ghislaine Maxwell. The Wall Street Journal reporting attributes the alleged birthday letter to a compilation created by Maxwell, a so-called Book of Letters, curated for Epstein's 50th birthday. If this is accurate, she may be in possession of critical information about the letter's origin, context, and authenticity. Though she is currently incarcerated, her testimony, whether in deposition or trial, is not precluded by imprisonment. If subpoenaed, she would be compelled to testify. Her statements could corroborate or contradict Trump's version of events. They could also implicate others, or clarify the internal dynamics of Epstein's social network, a realm that remains opaque and fiercely protected. All of this rests on a conditional. The case must survive the early motions. But herein lies a geopolitical dimension that transcends legal process. The broader implications of discovery are not confined to reputational damage. They could impact political calculations. They could influence donor behavior, media alignment, and international perception. For a man running once again for the presidency, the optics of a courtroom interrogation over ties to a convicted sex offender are profoundly destabilizing. There is also the question of counterpressure. Legal experts have warned that even if the case is weak on its face, the presence of executive power or its remnants can create informal pressure on defendants. Trump has a documented history of using presidential authority to shape commercial outcomes. During his term, he issued executive orders that targeted firms, mergers, and foreign transactions. Though those powers are no longer active, the precedent exists. The implicit threat of political retaliation, whether through policy, media, or litigation, hangs over every legal engagement he initiates. It is within this environment that media organizations must assess their response. Do they resist vigorously, risking further escalation? Or do they seek quiet resolution to avoid protracted public conflict? Thus far, the Wall Street Journal has given no indication that it will retreat. Its legal team is expected to respond with a motion to dismiss, likely invoking both the anti-SLAPP statute and the lack of specific factual allegations demonstrating malice. And yet, even if they prevail on those motions, the story is already global. The filing has drawn coverage from major outlets across the political spectrum. It has prompted renewed speculation about Trump's past, his associates, and the motivations behind his legal tactics. It has opened the aperture for broader conversations not only about the truth of a single article, but about the architecture of defamation law, the power of institutions, and the limits of journalistic protection. The invocation of defamation, especially by a political figure, is not a neutral act. It signals intent to dominate the narrative, to convert the press from observer to defendant, and to redefine dissent as danger. This tactic is not unique to the United States. Across the globe, authoritarian regimes and populist leaders have increasingly weaponized defamation claims to undermine investigative journalism, to erode public confidence, and to consolidate control over information flows. In democracies, the judiciary remains the last firewall. It is tasked with filtering political performance from legal substance, with measuring allegations not by how loudly they are broadcast, but by how well they are supported. That firewall, however, is only as strong as its independence. And in the current political climate, where partisanship penetrates even judicial appointments, that independence cannot be assumed. Which raises a final question for this chapter. Who benefits from the mere act of litigation? Even if the lawsuit is dismissed, Trump will have succeeded in galvanizing a segment of his base, in reframing himself as a victim of elite defamation, in casting doubt on the motivations of one of America's most prominent media institutions, and in reinforcing a meta-narrative in which every accusation is projection, and every critic is an enemy. That is not a legal strategy. It is a political one. And it may be more effective in rallies than in courtrooms. But it places new strain on the boundary between press freedom and partisan warfare. To understand the deeper implications of this lawsuit, one must step beyond the immediate controversy and examine the strategic use of defamation litigation as a political instrument. This is not the first time Donald Trump has initiated legal proceedings against a media entity, and it is unlikely to be the last. The tactic is not rooted solely in legal vindication. It is a tool of narrative management, one that can reshape public discourse without ever reaching a verdict. Throughout his public career, Trump has positioned lawsuits as leverage. He has used them not merely to seek justice, but to signal dominance, to intimidate critics, and to place the burden of defense on institutions that would otherwise hold him accountable. In doing so, he has exposed the asymmetry at the core of the American legal system. For while the First Amendment offers strong protections for free expression, the cost of defending against a lawsuit, even one with minimal legal merit, can be enormous. For major outlets like the Wall Street Journal, the financial burden may be tolerable. For smaller media organizations, independent journalists, or digital publishers, the weight of litigation can be existential. The chilling effect is well documented. Faced with the prospect of prolonged legal combat, many outlets choose retraction over resistance, silence over exposure, and thus, the lawsuit becomes not a plea for justice, but a method of censorship. In this way, defamation law operates in dual layers. There is the formal legal structure, defined by precedent and statute, and then there is the informal landscape shaped by political influence, public sentiment, and the resource disparity between plaintiffs and defendants. It is this second terrain that Trump has navigated with precision. Even when lawsuits fail, they often succeed in shifting the narrative, in exhausting the opposition, and in sowing doubt among the broader public. This strategy is not uniquely American. In countries such as Hungary, India, and the Philippines, similar patterns have emerged. Leaders and ruling parties have used defamation charges as instruments of suppression, cloaking authoritarian tendencies beneath the language of legal redress. In each case, the tactic is the same: to reverse the flow of accountability, to place journalists on the defensive, and to reframe scrutiny as slander. But there is a key distinction. In those regimes, judicial independence is often compromised. In the United States, the courts still function, however imperfectly, as barriers to politically motivated abuse of process. The anti-SLAPP statutes in states like California and Florida were designed specifically to identify and dismiss lawsuits intended to suppress free speech. And while these laws vary in strength and scope, their very existence is a recognition of the broader threat. In Florida, where Trump has filed the current complaint, the anti-SLAPP framework requires early judicial intervention. If the court determines that the suit arises from protected speech on a matter of public concern, and that it lacks probability of prevailing on the merits, it may be dismissed swiftly. This is not a delay tactic. It is a structural filter, one that reduces the risk of legal harassment cloaked as constitutional grievance. Still, even in this environment, the lawsuit serves a secondary function. It enables the former president to reassert his own framing of the Epstein connection. By initiating legal action, Trump positions himself not as a passive subject of accusation, but as an active denier, one taking formal steps to challenge what he describes as defamation. In the court of public opinion where legal outcomes matter less than headlines, this is a powerful gesture. The timing is also relevant. The lawsuit was filed in the middle of 2024, as Trump seeks to consolidate his position as the presumptive nominee for the Republican Party. The legal filings and the media coverage they generate redirect attention toward perceived victimhood, a theme that has underpinned his political identity since his first campaign. It is not merely a legal narrative. It is a campaign device calibrated to energize supporters, undermine adversaries, and distract from less favorable coverage. But what of the media itself? The Wall Street Journal occupies a unique position in the American press landscape. Unlike overtly partisan outlets, it maintains a reputation, at least among its readership, for editorial seriousness and economic literacy. It is a publication read not only by politicians and investors, but by foreign observers, diplomats, and multilateral institutions. Its influence is global. A lawsuit of this magnitude, implicating its credibility and ethics, reverberates far beyond domestic discourse. And that may be part of the calculation. By challenging the journal, Trump is not merely confronting an article. He is engaging in symbolic warfare against an institution that represents a particular stratum of elite consensus, a world in which facts are curated, analysis is credentialed, and criticism is cloaked in professional neutrality. To accuse the journal of fabrication is to accuse that entire ecosystem of ideological corruption. It is an attempt to recode credibility as complicity, and to delegitimize the mechanisms through which democratic societies interpret reality. This is not conjecture, it is strategy. And it follows a pattern seen in other spheres of contestation, from intelligence assessments to epidemiological data to electoral audits. In each case, the tactic is consistent: transform the adjudicators of truth into participants in a conspiracy, then declare that only the outsider, the disruptor, the victimized leader, speaks unfiltered truth. In such a framework, defamation law becomes a weapon of insurgency. It is wielded not to win in court, but to erode public trust in the court itself, to sow uncertainty, and to create informational parity between verified reporting and strategic denial. But this approach is not without risk. If the case proceeds, and if discovery unfolds, Trump may be forced to produce documents, testify under oath, or endure cross-examination on matters he has previously avoided. The courtroom, unlike the rally stage or television studio, does not offer the same latitude for ambiguity. Claims must be substantiated, evidence must be produced, and contradictions can become liabilities. Moreover, the legal system operates on timelines that extend beyond the news cycle. While political statements dissipate with the next headline, court filings remain. Depositions are transcribed. Testimony is recorded, and judicial rulings, once issued, carry the weight of legal precedent. What begins as a narrative maneuver may end as a binding judgment, one that shapes future litigation, institutional credibility, and public memory. It is in this crucible that the conflict between press freedom and political assertion will be tested. The stakes are not confined to one man or one publication. They extend to the very question of who controls the narrative in a democratic society. Is truth a matter of evidentiary process or of rhetorical dominance? Are facts determined by institutions or by ideological consensus? In the American model, the answer has always leaned toward institutional adjudication toward courts, journalists, scientists, and professional observers. But that framework is under sustained assault, not only from Trump, but from a growing constellation of actors who view procedural legitimacy as an obstacle to ideological control. This lawsuit, however it unfolds, is a symptom of that larger conflict. And as it progresses, the global implications will become harder to ignore. When the former leader of the world's most powerful democracy sues one of its most influential newspapers for billions of dollars, it does not go unnoticed. The international community does not observe such events in isolation. They interpret them as signals, indicators of institutional health, political maturity, and the credibility of democratic norms. In capitals from Brussels to Beijing, from Ankara to Abu Dhabi, policymakers, diplomats, and propagandists alike read between the lines. They study the legal filings. They analyze the media reaction. They watch for evidence of systemic decay or resilience. For authoritarian regimes, moments like these are not cautionary tales. They are opportunities. Opportunities to point out contradictions, to highlight hypocrisy, and to reinforce their own claims that Western liberalism is fractured beyond repair. When Donald Trump accuses the Wall Street Journal of manufacturing evidence, engaging in malicious character assassination, and operating under the protection of corrupt institutions, those allegations do not merely affect domestic perceptions. They supply rhetorical ammunition to foreign powers seeking to challenge the supremacy of American values on the world stage. In the People's Republic of China, state media outlets have increasingly drawn parallels between U.S. internal dysfunction and what they frame as the failure of Western governance. The Trump lawsuit, particularly if amplified through partisan media, becomes yet another data point in their narrative that American democracy is an illusion, a spectacle of elite infighting, judicial inconsistency, and media manipulation. In the Russian Federation, where the Kremlin tightly controls journalistic output, state propagandists have long framed American press freedom as a facade, a mechanism for regime-aligned elites to discredit opponents while feigning neutrality. When a former U.S. president accuses a mainstream outlet of conspiracy, it reinforces Moscow's central thesis that there is no objective truth, only competing power structures. But beyond the opportunism of autocratic regimes, there are real implications for U.S. allies. In Europe, where press freedom is a cornerstone of liberal democracy, legal attacks on journalism by a former American president generate concern. They cast doubt on the reliability of the United States as a normative leader. If the U.S. system can be leveraged by political actors to intimidate or delegitimize the press, then the credibility of U.S. advocacy abroad, particularly in regions undergoing democratic transition, is weakened. When the United States lectures emerging democracies on the importance of a free and independent media, while former leaders use lawsuits to wage war against reporters, that contradiction undermines the persuasive power of American diplomacy. It invites accusations of double standards and invites democratic backsliding in fragile states. This is not theoretical. In countries where the legal environment is already precarious, where investigative journalists operate under threat, the American example matters. If lawsuits like Trump's are perceived not as aberrations, but as permissible tools of political combat, it legitimizes similar tactics elsewhere. It enables those in power to argue that even the United States uses defamation claims to silence scrutiny, that even in Washington or New York, truth is subordinate to leverage. In this way, the Trump defamation case becomes a proxy not just for truth and falsehood, but for the strength or weakness of democratic institutions under pressure. The longer the case lingers in the public domain, the more it feeds into global narratives of democratic fatigue, polarization, and erosion of norms. But this global visibility also cuts both ways. If the lawsuit is dismissed, if the judiciary reinforces the principle that journalists cannot be silenced through litigation without proof of malice or falsity, it sends another kind of signal. A signal that the system still works, that the legal architecture built to protect the press, while imperfect, remains functional. That outcome would reinforce the value of judicial independence. It would validate the necessity of high evidentiary standards in matters of public controversy. and it would provide ammunition to journalists, lawyers, and civil society actors across the world who continue to defend their right to investigate the powerful. But there remains a deeper issue, one that transcends the outcome of any single case. The mere existence of such a lawsuit, the magnitude of its demands, and the prominence of the individuals involved highlight a structural vulnerability in the global information order. That vulnerability lies in the growing weaponization of credibility, the notion that truth itself is negotiable, that every accusation can be reframed as an attack, and that every journalist can be cast as an adversary. In this environment, litigation becomes a form of psychological warfare. It shifts the burden of proof. It forces institutions into reactive postures, and it redirects public discourse away from the substance of claims and toward the motives of claimants. It erodes the distinction between critique and conspiracy, and it trains the public to treat all information, even verified reporting, as suspect, unless it confirms their existing worldview. This is the terrain upon which modern politics is increasingly fought. Not over policy, not over governance, but over narrative control. In this contest, the legal system is not merely an arbiter. It is a battlefield, and the rules of engagement are shifting. One consequence is the gradual convergence of political and legal risk. Where once defamation lawsuits were relatively rare and bounded by professional ethics, they are now becoming expressions of ideological warfare. Politicians sue not to win, but to provoke, to claim victimhood, to pressure institutions into silence or compromise. This is not sustainable. For the global order to function, for democratic states to maintain credibility, legitimacy, and resilience, there must be a renewed commitment to truth as a civic good. Not partisan truth, not institutional bias, but verifiable, evidence-based information that can withstand scrutiny in both public and legal forums. The Trump lawsuit against the Wall Street Journal is a test of that commitment. It is a moment of institutional reckoning, not only for the American media, but for the democratic ecosystem as a whole. It asks whether the legal system will defend the principles of transparency, integrity, and open discourse, or whether it will be repurposed to suppress, to intimidate, and to retaliate. At stake is not just one man's reputation or one publication's credibility. At stake is the proposition that free societies require free information, that democratic power must coexist with democratic accountability, and that the truth, no matter how uncomfortable, cannot be litigated out of existence. If that proposition fails, then the boundaries between democracy and authoritarianism will blur further, and the world will take note. Within the United States, the reverberations of a defamation lawsuit of this magnitude are not confined to courtrooms or newsrooms. They penetrate the internal calculations of institutions, the operational habits of journalists, and the strategic assumptions of political actors. Even before a single motion is heard, lawsuits of this nature trigger institutional reactions. Media companies review their editorial processes. Legal departments preemptively assess risk exposure. Journalists begin to second-guess sources. Editors grow more cautious. And the implicit message spreads, reporting on powerful individuals, particularly those with the means and inclination to retaliate through litigation, carries a cost. This chilling effect is difficult to quantify, but impossible to deny. It is not the specter of censorship that alters journalistic behavior. It is the incremental pressure to avoid unnecessary legal entanglements, to be more careful, to be more restrained, to delay stories until every conceivable angle is triple verified. In theory, this enhances accuracy. In practice, it often delays accountability, and in some cases, it deters investigation altogether. This is not a weakness of the press. It is the structural outcome of operating in an environment where the threat of litigation is normalized, where lawsuits become part of the repertoire of political strategy, and where public figures view adversarial reporting not as a civic function, but as an attack to be countered, not with rebuttals, but with lawsuits. The legal precedent for resisting such pressure remains robust, but the financial and emotional toll of litigation is not evenly distributed. For large corporate outlets like the Wall Street Journal, The legal infrastructure exists to mount a defense. But for freelancers, regional reporters, or smaller nonprofit media organizations, a single legal threat can result in bankruptcy, career destruction, or worse. This asymmetry is exploited with increasing frequency. The line between defensive litigation and offensive suppression grows thinner each year. And while anti-SLAPP laws offer protection in some states, they are unevenly applied, inconsistently enforced, and often too late to prevent the damage. In this environment, the symbolic weight of lawsuits initiated by national figures, especially former presidents, cannot be overstated. Trump's legal action sends a clear signal: challenge me, and you may face the full force of litigation. And while many outlets will interpret that signal as a challenge to be met, others will interpret it as a warning to be heeded. This divergence in institutional response fragments the journalistic ecosystem. It widens the gap between outlets that can absorb risk and those that must avoid it. This is where precedent matters. If Trump's lawsuit is dismissed, and if the dismissal is upheld on appeal, it reaffirms the legal standard that powerful individuals cannot silence reporting without evidence of malice. It reinforces the judicial firewall between criticism and defamation, and it upholds the doctrine that public figures, by virtue of their influence, must accept a higher burden of scrutiny. But if the case survives, even briefly, it may embolden others. Politicians, corporate executives, and public officials who observe the outcome will draw conclusions not from the ruling, but from the process. They will see what it costs to defend oneself, how long it takes, what reputational damage accrues along the way. And they will add litigation to their toolkit not as a last resort, but as a preemptive tactic. In such a system, the risk calculation shifts. For the media, it becomes a question of allocation. How many legal battles can be fought simultaneously? For reporters, it becomes a question of career viability. How much exposure is tolerable? For editors, it becomes a question of strategic silence. Which stories are worth the institutional cost? And for the public, it becomes a question of trust. When the media appears constrained, hesitant, or fragmented, audiences lose confidence, not only in specific stories, but in the function of the press as a whole. And in that vacuum of trust, alternate ecosystems flourish, filled with unverified content, ideological narratives, and conspiracy theories disguised as analysis. This dynamic is not new, but the Trump lawsuit intensifies it. By targeting the Wall Street Journal, a publication generally regarded as serious and institutional, the lawsuit sends a message that no outlet is immune, that even those with legacy, resources, and corporate protection can be brought into litigation, that prestige does not insulate, and that proximity to the establishment does not guarantee safety. This realignment forces a deeper introspection within American journalism. For years, the industry has debated its role in the Trump era, how to balance objectivity with accountability, how to report on disinformation without amplifying it, and how to cover a political figure who routinely challenges the foundations of democratic discourse. This lawsuit crystallizes those tensions. If the journal defends its reporting, it must now do so not only in the marketplace of ideas, but in a legal forum. Its editorial decisions will be scrutinized by judges, possibly by juries, and certainly by the public. Every sourcing decision, every editorial choice, every verification step. This is not inherently unjust. Accountability is a core principle of journalism. But when that accountability is demanded, not through independent review, but through adversarial litigation, the purpose begins to shift. The point is no longer correction. It is deterrence. And deterrence is not accountability. It is control. Therein lies the broader concern. As litigation becomes more frequent, more publicized, and more politicized, it begins to erode the foundational premise of a free press, that journalists are not adversaries, but interlocutors, that their function is not to destroy, but to reveal, and that their legitimacy comes not from immunity, but from transparency. This balance is fragile, and it depends not only on judicial rulings, but on cultural norms, institutional resilience, and public support. In the absence of those supports, litigation becomes a form of cultural censorship, not enforced by law, but by exhaustion, not decreed by governments, but imposed by actors who understand how to use the legal system as a weapon of attrition. The Trump lawsuit, regardless of its merit, is part of this shift. It reflects a changing calculus, where political actors no longer fear the press, but challenge it directly, where the legitimacy of journalism is not debated, but litigated, and where institutions are forced to choose between resistance and survival. That is the domestic consequence of this case, and it may be the most enduring one. Should the Trump lawsuit proceed beyond dismissal, the legal terrain becomes less rhetorical and more forensic. At that stage, allegations give way to obligations. The parties must move from accusation to evidence, and the courtroom transforms from a symbolic platform into a procedural engine designed to extract, verify, and adjudicate truth under oath. This process is called discovery. For many litigants, discovery is a routine exchange of documents and testimony. But when the plaintiff is a former president and the defendant is a globally respected newspaper, discovery becomes a high-stakes contest over credibility, legacy, and institutional survival. At the center of this case lies a single artifact, a letter. According to the Wall Street Journal, that letter was allegedly written by Donald Trump to Jeffrey Epstein on the occasion of his 50th birthday. It allegedly includes a sketch of a naked woman and a cryptic inscription: "Happy birthday, and may every day be another wonderful secret." Trump denies the letter's existence. He denies drawing the image. He denies authoring the message. His lawsuit claims that no authentic copy exists and that the story was fabricated maliciously. But the legal system does not adjudicate based on denials. It operates on material evidence, and discovery may compel the production of precisely that. If the Wall Street Journal possesses the letter or any reproduction of it, the court may order its submission. The paper would not necessarily be required to reveal its sources, thanks to shield laws that protect journalistic confidentiality. But it may be forced to present the document itself to verify its physical existence, its authenticity, and its origin. This is a double-edged risk. If the letter is proven to be fabricated, it supports the plaintiff's claims of defamation. If it is verified as authentic, either through handwriting analysis, corroborating testimony, or metadata, then the lawsuit collapses under its own premise, and the plaintiff may find himself the subject of scrutiny rather than vindication. Worse still, the discovery process may extend beyond the letter. Defense attorneys are likely to request documentation of Trump's prior communications with Epstein, archived calendars, flight logs, emails, handwritten notes, voice messages, anything that could place the former president in social, financial, or operational proximity to Epstein or his known associates. Such requests would not be speculative. They would be justified on the basis that the lawsuit places Epstein at the center of the narrative. The moment Trump asserts that the alleged letter is false and defamatory specifically because of its link to Epstein, he opens the door to questions about his relationship with Epstein himself. That exposure could be expansive, and it may not stop with documents. Depositions would likely follow sworn testimony under penalty of perjury. Trump could be questioned not only about the letter, but about the broader context of his interactions with Epstein, his knowledge of the so-called Book of Letters, and his efforts, if any, to suppress related information. Attorneys may also seek to depose Ghislaine Maxwell. Though she is incarcerated, she remains a relevant witness. The Journal's reporting suggests she helped compile the Epstein birthday collection. If true, she may possess direct knowledge of the letter's existence, its provenance, and its intended purpose. Her testimony could either reinforce the Journal's position or dismantle it. In a normal civil suit, this level of discovery might be viewed as invasive but routine. In a case involving a former U.S. president, it becomes unprecedented. There are few examples in American legal history where a former head of state has been forced to submit personal correspondence for scrutiny, let alone under the shadow of association with one of the most notorious criminal figures of the modern era. For Trump, the discovery phase carries personal, political, and legal risks. Personal, because any documentation or testimony could be used in future proceedings, both civil and criminal. Political, because revelations could damage his electoral prospects and public standing. Legal, because inconsistencies under oath may result in new liabilities, including potential perjury or obstruction claims. In this light, the lawsuit appears increasingly precarious. By initiating litigation, Trump may have triggered a sequence that he cannot fully control. The narrative advantage gained by suing a major media outlet may prove temporary, while the procedural consequences of that decision may endure far longer. But there is a deeper implication here, one that transcends even the potential fallout of this case. By attempting to use defamation law to challenge a report tied to one of the most sensitive and reputationally damaging subjects imaginable, the Epstein scandal, Trump has effectively placed legal precedent on trial. If the courts entertain his claims without evidence of fabrication, malice, or negligence, it could signal a willingness to dilute the protections traditionally afforded to journalists. This would not remain an isolated development. In jurisdictions across the United States, lower courts monitor the treatment of high-profile cases. If the Trump lawsuit establishes even a partial precedent that defamation claims linked to politically charged reporting can survive initial motions without concrete evidence, it may embolden a wave of similar lawsuits. The legal threshold for silencing investigative journalism would begin to shift slowly, but definitively. At that point, the issue is no longer one of Trump versus the Wall Street Journal. It becomes a systemic inflection, a test of how much political power can influence legal standards, and how far the courts are willing to stretch procedural deference in the face of political confrontation. This is not merely a legal question. It is a constitutional one. The First Amendment exists not to protect popular speech, but to defend controversial expression, particularly when directed at the powerful. Defamation law is the narrow exception to that principle, designed not to punish journalists, but to protect reputations in cases of provable falsehood. To weaponize that exception, to turn it into a routine tool of political retaliation, is to invert the constitutional order. And it is to signal both domestically and abroad that even in the United States, truth may be litigated into submission. That is the precipice upon which this lawsuit now stands. It is not the court's job to resolve political disputes. It is its responsibility to enforce standards of evidence, due process, and impartiality. But in cases like this, where law and politics collide at high velocity, the burden on the judiciary increases, and the consequences of error are profound. The lawsuit filed by Donald Trump against the Wall Street Journal will, in time, be resolved by procedural rulings, evidentiary motions, or quiet settlements. But its true impact will not be measured in verdicts or monetary judgments. Its consequences will be written in how institutions behave moving forward, how narratives are shaped, and how legal tools are repurposed by those with power. In this sense, the case is not just a legal event, it is a referendum on the architecture of accountability. The former president has launched an attack not only on a particular article, but on the legitimacy of journalism itself. He has framed critical reporting as conspiracy. He has positioned himself as the aggrieved party, and he has leveraged the courtroom as a stage upon which to reenact the political theater of grievance and retaliation. The implications are strategic. If this lawsuit succeeds even partially, it will demonstrate that the boundary between public criticism and actionable defamation is now pliable, negotiable, contingent upon political force. It will signal to other political actors that media institutions can be disciplined through courts, that reputational injury can be converted into litigation leverage, and that uncomfortable truths may be buried beneath procedural complexity. Even if the lawsuit fails, its chilling effect will persist. Journalists will remember the cost of scrutiny. Editors will remember the liability. Publishers will remember the headlines, not of the article, but of the lawsuit that followed. And the next time a reporter receives a lead, that touches on a powerful figure, the instinct may not be to pursue the truth, but to avoid the risk. This is how institutional memory works, not through law, but through caution. And that caution is cumulative. Over time, it reshapes the incentive structures of journalism. The most sensitive stories are left unpursued. The most powerful figures are left unchallenged. And the most dangerous truths are left unrevealed, not because they are false, but because they are legally inconvenient. In a functioning democracy, this outcome is unacceptable. The role of the press is not ornamental, it is foundational. It serves as a check against consolidated power, a mirror to public corruption, and a bridge between private knowledge and public understanding. When that function is compromised, whether through coercion, financial exhaustion, or strategic litigation, the balance of democratic power shifts, and that shift is rarely reversed. It is tempting to treat the Trump lawsuit as exceptional, the product of a singular personality, a unique political history, and a polarized media environment. But that framing is insufficient. The tactics employed here, discrediting sources, framing criticism as personal attack, litigating narratives instead of facts, are not confined to one individual. They are becoming the norm in political movements that view institutions not as safeguards, but as adversaries. This trend is global. It is not limited to the United States. In Brazil, India, Hungary, and Turkey, defamation lawsuits have become routine instruments of political suppression. Leaders invoke legal remedies not to protect truth, but to control it. And they justify these actions by pointing to similar tactics used elsewhere, including in the United States. This is the geopolitical consequence of cases like this. They normalize the idea that journalism must defend itself in court, that the presumption of good faith does not apply to those who investigate power, and that the legal system can be conscripted into partisan warfare. These ideas do not fade with dismissals. They metastasize. They are studied, replicated, and adapted to new contexts where judicial independence is weaker and press protections are more fragile. This is why the outcome of the Trump lawsuit, even if resolved quietly, will be studied far beyond American borders. It will be used as precedent, as justification, as warning. But beyond international replication lies another, more profound risk: the erosion of civic consensus around the very idea of truth. In an environment where every accusation can be reframed as defamation, where every investigative report can be dismissed as fabrication, and where every journalist can be rebranded as a political actor, the epistemic foundation of democracy begins to fracture. Citizens cease to trust, institutions cease to function, and political identity replaces empirical evidence as the basis for belief. This is not a hypothetical. It is observable. Polling data across democratic societies reveals declining trust in media, increasing suspicion toward legal institutions, and growing belief in conspiratorial narratives, particularly those that absolve leaders of wrongdoing and place blame on the system. Lawsuits like the one Trump has filed contribute to this decline, not necessarily by what they prove, but by what they imply. They imply that truth is partisan. They imply that investigation is aggression. And they imply that power is immune to scrutiny. In response, the defenders of liberal democracy must be clear not in their rhetoric, but in their institutional posture. Courts must reaffirm the high bar for defamation. Media outlets must continue to report without fear. And civil society must recognize that freedom of the press is not a luxury of stability, but a requirement of sovereignty. The most dangerous outcome of this lawsuit would not be a loss for Trump. It would be a victory for silence. Silence among journalists, afraid of reprisal. Silence among editors, worried about cost. Silence among courts, reluctant to dismiss politically charged cases. And silence among citizens, uncertain of whom to believe. This is how democratic decay begins. Not with overt repression, but with the slow normalization of litigation as intimidation, of doubt as default, of power as arbiter of truth. The Trump lawsuit against the Wall Street Journal may not reshape the law, but it will test the integrity of the systems that uphold it. It will reveal whether institutions built for accountability still function under pressure. It will show whether the First Amendment, long a symbol of American exceptionalism, still holds firm when confronted by those who would weaponize its exceptions. And it will signal to adversaries and allies alike whether the United States remains a country where truth is defended, even when it is inconvenient, even when it is uncomfortable, even when it is politically dangerous. That signal matters, not just for this moment, but for the system that must survive it.